Good morning. My name is Graham Bellinger. I'm the managing partner of Kidd Rapinet's London office. Welcome to this webinar. Kidd Rapinet was one of the first firms in London to specialise in immigration law more than 40 years ago. I'm delighted to say we've continued to specialise in this area. Today, my firm's head of immigration, Gooch here, and Kirsty Tuffery, the solicitor in his department, will host and present this webinar, and it's going to be concentrate on the changes to the immigration system and particularly changes for skilled workers and the rights of EEA and Swiss nationals to work in the UK from the 1st of January 2021. The webinar will last approximately 20 minutes, and then it'll be followed by the opportunity to take questions using the chat function, which should be on the base of your screen. Please do use that. If there are any questions that are unanswered at the end of the webinar, please feel free to either telephone or send an email to Kirsty, and they'll be happy to assist and provide you with the answers. The session will stop promptly at 12 noon, but once again, please do follow up with Kirsty and Gooch afterwards. I'll now pass you over to your hosts and presenters, Gooch, who's head of immigration, and Gooch, over to you.
Thank you very much, Graham, for that introduction. My name is Gooch here. I head the immigration team at Kidd Rapinet, and at today's webinar, I'll be joined by my colleague, Kirsty Tuffery, an immigration solicitor in our immigration team at Kidd Rapinet. During the webinar, we'll be looking at the changes that are coming up, and I will give you a short background to the changes and some context to the changes and some timelines. My colleague Kirsty will then focus on some of the specific changes, and we'll take you through those. And at the end, in conclusion, we're going to try and give employers and businesses some tips on how best to deal with the changes, plan for the changes, and deal with compliance issues to avoid hefty fines for non-compliance. Now, we're going to first of all start with what is happening. Now, what is happening is very significant. For the very first time since the EU joined the European Union, deal or no deal, as of the 1st of January 2021, EU nationals and Swiss nationals will no longer have the automatic right to live and work in the UK. Therefore, for employers, this is very important because access to a very large labour market is lost. As of the 1st of January 2021, EU nationals, Swiss nationals will be subjected to the same formal procedures and processes if they wish to work, study or live in the UK. As I just said, that's the first time this will happen since the 1st of January 1973 when the UK joined the European Union. It is a dramatic change. Just to give you a very quick example, as of the moment, if you're an employer, you're looking to hire, for instance, a hotel manager, waiting staff, you can do so from any EU country, and all you need is the identity of that individual and you can onboard them immediately. As of the 1st of January 2021, you will not be able to do that. Another example, which may put this in some sort of context, footballers. At the moment, any footballer can be signed for a professional club if they're from the European Union. As of the 1st of January 2021, they will also need to follow formal processes and obtain formal permission to work in the UK. Next, we're going to look at why is this happening, just to put it in its context. Just explain that there will be these changes on the 1st of January 2021. Since January 2020, which is when the UK left the European Union, there's been a transition period. And this transition period ends on the 31st of December 2020. This is coming up, so therefore after the 1st of January 2020, two systems are going to be aligned. At present, and since we've been in the European Union, EU nationals and their families have been regulated and governed by what are called the EEA regulations. All other nationals have been governed by and regulated by the immigration rules. As we will be out of the European Union, the system will all merge into one, so that the immigration rules will then apply to all nationals. Because of this, there are changes to the skilled worker route that are coming in. And the reason for this is, as I mentioned earlier, the UK is losing access to a very large labour market, and employers had concerns about this and skill shortages and how they would be able to fill vacancies. In changes to the skilled worker route, which Kirsty will take you through, the government has said that employers will be able to hire people at lower skills in the future, and that they will be able to hire not just from Europe, from anywhere else in the world. Now, the timelines for this, there are three very important timelines for you to consider. The first timeline to consider is the 1st of December 2020. This is when the changes to the skilled worker route came in, and which Kirsty will be discussing with you. As I just mentioned, employees had concerns about loss of a very large labour market, and the government has said, don't worry, we will help you facilitate the hiring of workers with lower skills. The next date to consider is the 1st of January 2021, which I've just mentioned, because as of that date, any EU national or Swiss national who wants to come to the UK will need formal permission to work in the UK, to live in the UK, to study in the UK. The cut-off date is the 31st of December 2020. The next date is the 30th of June 2021. That's the date by which any EU nationals and their families who have been living in the United Kingdom before the 31st of December 2020 and have not yet regulated their status would have needed to have done so using the EU settlement scheme. Those are the timelines that you should be aware of. You may have received lots of communication and correspondence and seen ticking clocks on all sorts of communication that the Brexit exit is approaching. What I'm going to do now is hand you over to Kirsty, who's going to take you through some of the specific changes to the skilled worker route, which are, again, significant changes, they're important changes, and the government are relying on these changes to allay the fears of employers with regards to skill shortages once we leave the European Union on the 31st of December 2020.
Thank you, Gooch. Hi everyone, and thank you for joining us today. So you've probably noticed that there's been a lot of talk lately of a new point-based system coming in from 2021. What a lot of people don't realise is we do actually already have a point-based system in place, and that existing system has had a bit of a revamp, and that's what I want to talk you through today. So firstly, that I can highlight what the position is going to be for companies that are employing EU nationals that haven't yet needed to understand the requirements for sponsorship, but also to consider the positive impact and the opportunities that that's going to create for businesses who are sponsoring migrants from outside of Europe already. So before I set off on what's changed or what's going to change, there are some factors that are remaining the same as under the previous system. So if you want to employ an overseas national, be it someone from Europe or anywhere else around the world, you're going to need a sponsor license. So if you haven't already got one of those, you're going to need to get one in place. That will enable you to sponsor your employees. Now, once that license is in place, you'll be given access to a sponsor management system, which is essentially like an online portal for your license, and then through that system you'll need to assign certificates of sponsorship to the individuals that you want to employ, those migrant workers, who can then use that certificate to go on and make their own skilled worker application for their visa. In terms of the actual proposed employees, they are still going to need a job offer for a genuine vacancy, and they're still going to need to meet that English language requirement, which is currently set at level B1. They're also going to need to undergo the criminality and suitability checks as part of their application. But in terms of the changes, what I'm going to do is, first of all, I'm going to outline 4 key differences, and then I'm going to briefly touch on a few of the other changes that are likely to have an impact on your business. So the first noticeable change is that the route's going to be rebranded, and what we previously knew as Tier 2 General, that's now going to become the Skilled Worker Visa. Secondly, and more substantially, we see the abolition of the resident labour market test. So under the previous system, if you wanted to sponsor a migrant worker, a company was typically expected to carry out what we call the resident labour market test. And that was essentially a 28-day advertising exercise to assess the resident labour market and see whether there were any British, settled or European workers who could fill the position before you could offer that job to the migrant worker. That requirement's now being scrapped, which is really welcome news for businesses who are currently employing migrant workers from outside of Europe, because it's actually going to make the process a much quicker one. There's no longer going to be that mandatory requirement to advertise the post for 28 days before offering the job to a migrant worker, which is really positive. The third major change that we're going to see, or we've seen, is in relation to the skill level of the job. Now, employers are now going to be able to sponsor at a lower skill level, as Gooch mentioned earlier, than what they previously could under the system that was in place before. So before the 1st of December, the job that you were seeking to fill had to be skilled to RQF level 6, and that was essentially equivalent to a degree level. Now, under the new system, the job only needs to be skilled to RQF level 3, which is equivalent to the skill that someone would acquire at A level. It doesn't mean, just to be clear, that the actual individual has to have an A level or hold A levels, but just the job itself is skilled to that level. So what it means is that the pool of skilled workers that the sponsoring employers, such as yourselves, are able to fish from, that pool's now going to be much wider than what it previously was. And to give you a few examples of the types of jobs that you're going to be able to sponsor or not sponsor individuals for, we've now got, that previously wasn't possible, we've got retail, bar and hotel managers, we've got office managers and PAs, fitness instructors, car paint sprayers, plasterers and carpenters. But there are still some roles that you can't sponsor individuals in. That's things like on the other side of the screen at the moment, bookkeepers, payroll managers, legal secretaries, hairdressers, pharmacy dispensers, travel agents. Those lower skilled jobs, there's no provisions within the immigration rules in order for you to employ those types of workers. So unfortunately, you're going to lose access to them if they're coming from Europe after the end of the year. The fourth and final key change that I'd like to mention is in relation to the salary thresholds. So previously, employers were required to pay an experienced worker at least £30,000 or the appropriate rate for that particular job role. And that appropriate rate would be set out in the Code of Practice for Skilled Workers. So whichever of the two was higher, that's what you would have to have paid the individual that you wanted to employ. Under the new rules, however, the minimum salary threshold has now been set at £25,600 or the going rate for that particular role. Again, you find that in the relevant appendix, and you need to pay whichever of the two is higher. So because of this lower threshold, it's obviously going to be opening up more opportunities to hire from outside the UK. And the new system itself is actually going to be a lot more flexible than the previous system. In the past, it wasn't possible to trade part of the salary for other characteristics that the individual might have, such as qualifications and things like that. So where that £25,600 salary threshold that's now been set, where that can't be met, under this new system, it might still be possible for you to sponsor a skilled worker on a lower salary, as long as you don't pay them below the bare minimum amount of £20,480 per year. And that would be, for example, in the cases where you're sponsoring someone in a role that falls on the shortage occupation list, which is essentially where, you know, we've got a shortage of those particular job roles in the UK. There's a list of types of jobs that can be found on this list, essentially where there's a shortage of those roles here. Also, it might be where a new entrant's coming into the labour market rather than being an experienced worker, or perhaps they've got a relevant PhD for the job that you're looking to fill and that you want to sponsor them in. Or some of the jobs that are some of the listed health and education occupations, they're also the types of people that can potentially trade the salary for this type of characteristic. So in these cases, the relevant discounted rates of either 70, 80 or 90% can be applied to the going rate that you would have to pay for the role in question. So you can have a look at on the slide at how some of those discounts apply to the relevant characteristics. And to give you an idea of how that works in practice, I've got a case study that I'd like to talk you through, just to try and make it a bit more easier to understand in case it's still not quite clear. So let's say you want to hire a web designer for your business. The starting point would be to consider whether the salary threshold is the standard minimum at 25,600 or the going rate as set out in the Code of Practice. Now, for a web designer, the Code of Practice indicates that the going rate is £26,000 for this web designer, which is higher than that standard minimum threshold that's now set at 25,600. So in theory, it would be necessary for you to pay the going rate of £26,000 because that's higher, the higher of the two salaries. However, a web designer is currently found on the shortage occupation list, and you can therefore apply that 80% discounted rate to the going rate of £26,000. So the minimum you would need to pay a web designer in these circumstances would be £20,800. That's 80% of the 26,000, and that amount still exceeds that basic salary of £20,480 that I mentioned earlier. So hopefully that gives you an idea of how the discounts work, but if you do need any help of understanding the salary that needs to be paid for somebody that you want to employ, do give us a shout. We'll be happy to help with guiding you through that. And besides these 4 key changes, I've got 4 other amendments that I actually wanted to touch on today. The suspension of the annual quota of applicants is the first. So previously, we had a quota of 20,700 Tier 2 general applicants who could apply per year, with a few exceptions to this. It was necessary, therefore, to go through like a monthly panel process in order to see whether you could sponsor the migrant worker before you actually went ahead to do so. That's no longer going to be the case because that quota no longer applies. It's going to be another factor that's going to be speeding up that end-to-end process and making it quicker for you to get those employees through the door and into your business. So that's really welcome news. The second amendment that I wanted to mention here was the cap on how long an individual can hold a skilled worker visa has been removed. Previously, the maximum duration for holding a Tier 2 visa was set at 6 years. That's no longer going to apply. So as companies, you don't now need to worry about how long you're going to have access to those talented employees that you've invested all your time and your effort into, if they're not yet in a position to qualify for indefinite leave. Thirdly, the 12-month cooling off period's been abolished. So what that means, under the old system, unless an applicant fell within one of the few exceptions, they had to wait 12 months from the expiry of their Tier 2 visa before they went ahead and reapplied in that category. That's no longer going to be the case. They don't need to wait any longer. And finally, the scope for switching between immigration categories is actually going to be opened up. So, for example, someone who's in the UK currently on a Tier 5 visa as a temporary worker, they're no longer going to have to leave the UK in order to make an application to return under the skilled worker route. In the past, they would have had to have done that, but that's no longer going to be necessary. So Hopefully that just means that there's going to be a bit less disruption for your business if you're currently employing them and you want to keep them on. So while it might seem that these changes are more of a hindrance than a help for you, hopefully you can see that there are quite a lot of positives that can be taken from the new system. And if you're a business that still wants to hire workers from the EU from 2021, and it's not really going to be as harsh or restrictive as it would have been if that old system that applied to non-EU skilled workers was going to be maintained exactly as it was before. So I'm now going to hand you back to Gooch so he can summarise why it's important to plan and suggest some steps that you can take to prepare for the changes.
Thank you very much, Kirsty. I hope you would have gathered from that with the changes, there are opportunities for employers, despite losing access to the European Union labour market. Just a couple of the things Kirsty mentioned there that are very important. Switching immigration categories. Previously, we had instances with clients of ours where they had to go all the way back to Australia to make an application to come all the way back. Those sorts of procedures won't apply, which will be much better for businesses and for those individuals. And she did mention the skill levels being lowered, which will be very important. In terms of what employers and businesses should do and plan for, the first thing we would say is if you have not already, as a business, or do not hold a sponsor license, would be to apply for one and try and obtain one. Otherwise, you will not be able to employ an overseas national should you have the need to do so. There is a process for doing this, and the Home Office will have to be satisfied about the credibility of the employer. And it's important that you prepare those applications properly, because if the application is refused, it could be 6 months before you can reapply. That will obviously be detrimental when you're trying to onboard an important employee. We do at Rapinet assist lots of employers with those applications, and it is important to get those right, so your onboarding and everything else can run smoothly. Secondly, if you've got workers that you are about to hire from the EU who don't already live in the UK, and they were to begin work in January, February, March, bring them on board now. Because if they come now and they're from an EU country or a Swiss national, you won't have to go through any formal processes in order to have them working for you on a local basis. So don't wait, just try and move them forward. Thirdly, you probably have workers who are from the EU. Now, they should already have tried to regulate their status. If they've not already done that, you must encourage them to try and do that before the 31st of December, if at all possible. And in any event, by the 30th of June 2021, if they can show that they were resident in the UK before the 31st of December 2020. It's important so that they can continue working for yourselves lawfully. Fourthly, we think you should audit your employee records just to check that your employees have the lawful right to work in the United Kingdom. If they do not, you could be subjected to very severe civil penalties and fines, and that can be up to £20,000 per worker. To put that in context, if you're a small business and you have 2 employees who are found not to have had the lawful right to work in the United Kingdom, you could face a fine of up to £40,000, which could be disastrous for your business. So it's important to have the right documentation for those employees, for the right to work checks, and again, we can assist businesses with this. There are other matters that you should be aware of in terms of your planning. One is costs. If you are going to onboard employees from overseas, there will be a cost in the visa process, and there will be timelines. Kirsty's mentioned that under new changes, some of the timelines should be quicker, but even then you have to build those timelines in. You won't just be able to onboard overseas nationals immediately. You've also got to remember that low-skilled workers are still not covered, even though Kirsty mentioned the skills thresholds which have to be met. There are certain occupations which won't be covered, and you won't be able to sponsor those employees. But employees must still be aware of the skills thresholds for employees they may be able to sponsor, those that Kirsty mentioned, for instance, in what's called the level 3 categories. So it's important for employers to bear in mind that we'll have to meet those salary thresholds and factor in that cost. We hope this has been useful and it gives you some clarity on the changes. There is a lot of talk about this in the media, in the newspapers, but essentially this is what these changes are about. They are significant. We will be having a new immigration system and it will now cover everybody, and there'll be no distinction between EU nationals and Swiss nationals and overseas nationals from anywhere else. Thank you for joining us, and I think we're going to take some questions now that have come in, and I'll pass you over to Kirsty.
Yep, thank you. Please do send in your questions via the chat feature if you've got anything that you want to ask or clarify. We do have a couple of questions that have been sent in prior from people that couldn't actually join today. Perhaps they'll be useful for anyone listening, so I'll go through those anyway. We're going to be sending out the answers to those by email to those individuals, but if you have got any other questions, do send them in and we'll be happy to try and address them for you. So the first one I've got here, someone's asked, I currently employ a Spanish national who's been working for my business since 2019. What do I need to do? I'm happy to take that one, Gooch. So you don't need to actually sponsor that individual, even from 2021, if they've been working here and resident here before the end of the transition period. That individual is, however, going to need to regulate their status under the EU settlement scheme before the 30th of June, as Gooch mentioned, in order to be able to continue working legally in the UK from beyond that point. So if they haven't already done so, as Gooch mentioned earlier, again, you probably want to try and support them through making that application, finding out if they've even looked into doing the application yet, or if they've made an application. You don't actually need proof that they've secured that status right from the 1st of January. You can still rely on just their EU passport for proof of their right to work initially. But from after 30th of June, that's when we're going to be needing, or you're going to be needing, sight of their confirmation of status under the EU settlement scheme. So it's useful to bear that in mind. Was there anything else you wanted to add, Gooch? Are you happy with the...
No, I mean, just to give an example of that, I have a very close friend who runs a small business. We've been discussing this for 3 years, and we just found out the other week that one of their key employees that they employ, who's an Italian national, had still not regulated, and we're 3 weeks away. So human nature is to leave these things to the last minute. As employers, try and encourage your employees to do this. It's in their interest.
Yeah, absolutely. The second question that's come in, maybe you want to take this one, Gooch. If my company already holds a Tier 2 sponsor license, do I need to apply again for this license to cover skilled workers in light of these changes?
No, the short answer to that is no. If you've already got a sponsor license, you don't need to do anything to obtain a new one. And what the Home Office is doing is that normally you can reapply. It's normally for 4 years. You can reapply for your license. They start sending reminders up to 90 days before the expiry date. But at the moment, the Home Office are saying that if you want to try and renew your license now, you can do so, and they will deal with it earlier. This is all part of the government's response to employers' fears of shortages, saying we're going to make it easier for you to try and hire people.
Thank you. Gooch, Kirsty, we've got a couple of questions coming in. There's one here from Lisa that says, are you allowed to ask your EU nationals for evidence that they have applied for the EU SS?
I don't believe so as yet. It's not mandatory to have that until after 30th of June. You can mention that you're going to need it from then and suggest that perhaps they can provide it to you now, but at the moment you can continue to accept the EU national passport.
Okay, thank you. There's another one here from Rita that says, for UK companies hiring in the EU, i.e. Germany and France, is there any change to that?
I think if it means they're hiring from and coming to work in the UK, the change is they should come and start working here before the 31st of December. Otherwise, they will have to apply for formal clearance to come here under the skilled worker route.
Okay, Rita's saying they're actually on UK contracts.
And are working in the EU.
I'm just waiting to see if there's a response.
Yeah.
It looks like they're based in Germany or France, but they actually are on UK contracts. I don't know whether that's something that you can answer, whether that's maybe a longer answer.
If I think it's a longer answer if it's to do with third country contracts, and there is something called the Van der Elst principle, whereby workers who are third country nationals are working for an employer in one EU country and then needs to go and work in another EU country. And that's normally covered by those provisions, but it probably needs a longer answer in some more detail.
Okay, thank you. Perhaps Rita, you could get in contact with either Gooch or Kirsty, but thank you for your questions.
I've got one more that's come in. I know we were due to end sharp at 12, but there's someone here currently employing a Greek national who was resident and worked in the UK this year on UK PAYE. They returned to Greece temporarily later in 2020, and it's unlikely they're going to be back by the 31st of January. I think, yeah, they've corrected 31st of December. Is there anything they can do if they haven't returned? If they haven't yet applied under the scheme, then they really do need to make an application before ideally get them back here before the end of the year, make the application. If they've already applied under the scheme and have the status already, that status will be maintained. They don't lose pre-settled status or settled status immediately just upon leaving for a short period. That period's exceeded 6 months, there may be an issue in terms of qualifying for settled status later down the line if they're only on pre-settled status at the moment. And that's where the complication is going to arise for them when it comes to actually settling if they haven't as yet. But if that pre-settled status is valid and they're only going to come in temporarily for a little while, or a couple more years, and don't intend to settle here, then it shouldn't be a problem because they won't have lost it already if they only left the UK this year. So I think that concludes us for today. If there is any other questions, as we mentioned earlier, please do drop us an email or give us a call, and we can perhaps set up a meeting and take you through this and get those licenses in place if you need them. So thank you all for joining us, and goodbye.